is the Investor Connect podcast program. This is Hall T. Martin. I'm the host of the show, in which we interview angel investors, venture capital, private equity, family offices, and many other investor groups for startups and growth companies. I hope you enjoyed this episode. Thank you for joining us. Hello, this is Hall Martin with Investor Connect. Today we're here with Christopher Ezold, partner at Wisler Pearlstine. Wisler Pearlstine is a Pennsylvania-based law firm specializing in business, employment, and corporate law. They help startups and investors navigate legal challenges, including non-compete and non-disclosure agreements. Christopher, thank you for joining us.
It's a pleasure to be here, all.
Great. So where are you calling from today?
So I'm in suburban Philadelphia. In one of our office locations, we have a number of locations in the Pennsylvania area, and this is our primary.
Right. So what was your background before joining Wisler Pearlstine?
I had a family firm for about 25 years and focused primarily on health law, and I have a master's degree in tax because you can't really do the transactions in the corporate world without it, and have built a practice serving primarily healthcare, emerging growth companies, and larger organizations as outside general counsel.
So what excites you right now?
There's a lot of change coming. The law never gets smaller. No one takes laws off the books. So the law books today are thicker than they were when I went to law school 30 some years ago. And we're seeing a whirlwind coming this year and the next couple of years. It's going to change a lot of things. So it's going to keep us dancing. One of the major changes I see coming, and I think a number of other people do, is how non-competes are handled. That's one of the things I think we were going to talk about today. And there's changes from both the top and the bottom, I think, in that area, which is also a little unusual. And I've been handling and litigating non-competes for 30 years, so this is definitely something I'm finding exciting.
Oh, great. So let's talk about non-compete agreements. I work with a lot of startups, and whenever we work with them, we're always signing non-compete agreements. And there's always been a question about legality of those things. But before we get into it, can you tell us more about what they are and why startups use them?
Sure. So a non-competition agreement is a type of agreement called a restrictive covenant that includes non-competes, non-solicits, confidentiality agreements, etc. Each of these agreements is treated just a little bit differently by every state. So by the time you get from Maine all the way up to California, now it's much different. And certain states outlaw them, others limit them, others don't do anything at all. And one of the new challenges for non-competes is a distributed workforce and work from home. Back in 1995, very few people didn't work at their office. Now, a lot of people don't work, and they are in other states. And do the non-competes still work there? So that's one of the big issues that we're facing. This is especially important for startups, which are particularly distributed, have much more likely to be having their key employees in different states than your more large or organized companies.
Well, great. Well, these laws vary from state to state. How do they impact non-compete agreements?
Sure. Most states require that non-compete agreements be related to an employment agreement or an agreement for the sale of a company, your equity in some kind of entity. They don't let most businesses agree not to compete with each other because the whole point is to have free competition. Again, most states require that non-compete agreements also are reasonable in time. They can't be for 100 years. They're reasonable in geographic scope. If you're only running a business in New York City, can you stop someone from working in San Francisco? Of course not. And then they have to be reasonable in what I call substantive scope. And different states really talk about it differently. But if I'm the CEO of a company, can I be prevented from working as a janitor at a competitor? Now, the reality is, if I go work as a janitor at a competitor, it's probably a sham. But if it's real, if I'm really just picking up that job now and I'm completely changing the trajectory of my career and I'm not doing anything that would really have anything to do with what I did as a CEO for my prior company, a lot of states won't enforce it. There also has to be the ability of the person to earn a living. You can't stop someone from completely earning a living. And then different states will have different sets of requirements. Different parts of these analyses have different weight in different states. Their case law has developed differently over the years. So you really need to know each state. Some of them require that you be handed trade secrets the minute you sit down at your job. That was Texas until that changed. Others, like California, don't like them at all. And others, yeah, they don't mind, but you can't do it with a doctor or a nurse practitioner, many of whom are in startups and providing some sort of medical service at the same time. So you really need to know the state you're in to make sure that the documents work. What's also important is you need to know that the people that you're working with don't move, because you could have a completely enforceable non-compete in Virginia, and then your employee moves to Maryland and things change. And you don't even know they moved. And all of a sudden you've got a non-compete that's not enforceable. They know your secret sauce, you own a liquidity event, and the buyers are looking in and saying, wait a minute, why would I buy this? Because your employee can take your secret sauce and walk. So now you need to know not just, do my employees that have the secret sauce, do they have a non-compete? But now you have to guarantee that they're not going to move to a place where that non-compete becomes invalid and destroys the value of the company.
Well, there have been some recent changes in the laws. What should investors be aware of that's changing out there?
So there's a lot of changes, and they're from the top and the bottom, like I said before. At the top, the Federal Trade Commission earlier this year issued a ruling saying there won't be non-competes. And it was more complicated than that, but that's essentially what it said. Eventually, that was overturned. But you can see that there was movement at the top of our government to do something about non-competes. I don't see that happening in the next 4 years, but 5 years from now, who knows? The same thing is going on at the state level, and it's going on in a number of different areas. Non-competes in general, we're seeing legislation being passed in states forbidding them, limiting them, and putting requirements on them that you have to be aware of. Then there's also not just non-competes in general, but specific ones. Healthcare non-competes, small business non-competes. We have legislation being passed on those when larger legislation forbidding all non-competes doesn't pass. And so if you're a non-compete, if you're in a small emerging growth company and you're developing a medical product and you're out there providing services, medical services, well, you need to know where medical service non-competes don't work. If you're a small business, you need to know where small business non-competes don't work. And again, you have to make sure your employees who have them don't move to other states and all of a sudden invalidate it. There needs to be some sort of an agreement preventing that move and ensuring the restriction stays in place.
So what makes a non-compete agreement, reasonable and enforceable? How do people write these so that they work in most states?
So a couple of the keys are breaking out the terms. If you have a non-compete and a non-solicit, you want them separate. You don't want them in one paragraph. And the reason is, if something is struck by the courts, usually these agreements will have a provision that says, look, you can strike the part that's illegal, but the rest of the agreement stays. So you don't want the paragraph struck to contain everything. You want to break these out into different sections. The reasonableness does vary state to state, but in general, 1 to 2 years for an average employee, up to 5 for someone critical, is very important. You can have those non-competes because those tend to be reasonable in every state. The geographic scope really has to be limited to where you're going to do business, but these days, most of the non-competes I see in emerging growth companies are from companies that are going to produce a product or a service that really is nationwide. No one is producing a small company hoping for a large liquidity event, but only because they're working in Philadelphia, Pennsylvania. That doesn't happen. So most of the time, a nationwide, maybe even worldwide limitation is going to be reasonable. One of the things you can do is make sure that all your employees don't have access to all of your secrets. Only those employees who need access to certain secrets get that access. And there's 2 really good reasons for this. One, if that non-compete is invalid, you haven't really released everything. 2, you have what are called trade secrets. Frequently, emerging growth companies don't have patents, they don't have copyrights, but they have trade secrets. A secret sauce that's useful and valued because it's hidden. And almost all states require that the employer that owns that trade secret has to take an effort, has to take steps to make sure it stays secret. So if you leave your secrets out for everyone to see, the courts aren't going to enforce them. But if you restrict them so only certain people get to see what they need, then a court's much more likely to enforce a non-compete, or rather an NDA and a non-compete that's based on trade secrets, because frequently that's what happens.
So let's talk about non-disclosure agreements or NDAs. Those also come up very often with startups. How do they protect startups, and what do you put into them to make them a strong NDA?
So NDAs are critical because there isn't a startup out there that doesn't have some kind of confidential information. Even the ones that are nothing but a land grab, first mover, still have confidential information they don't want to give out. And frequently that's going to be customer information. They will have secret sauce, they'll have patents, they'll have trade secrets. So these are all critical for these emerging growth companies, because if you aren't able to protect who and what you are, no one's going to buy you. Because why should they buy something that they can't protect, that they cannot make sure that no one else can have? To make them enforceable, you got to check the states you're in, make sure you follow the specific rules of those states. And there is the Protect Trade Secrets Act, which is a federal law that's only a few years old, and you have to make sure you have the right provisions in your agreement so that it's enforceable. Otherwise, the courts will just throw it out. In addition, you can have penalties, because frequently you don't know what the harm is. If someone takes your secret sauce and publishes it somewhere, to a competitor, online, to some people they know, what's the harm? Well, it looks existential, but maybe it is, maybe it isn't. You can put damages in the agreement that says, look, if you release this stuff, you're going to owe us $100,000. So when you don't know what the damages are going to look like, you could quantify them. That number alone will stop a lot of people from doing things they shouldn't do. And it can help make them think twice about those things. You also want to put in requirements that they tell you, hey, I have disclosed this information. I know someone else has disclosed this information. When I leave, I promise I will tell you where I go. Because frequently people will leave, and especially if they're going to a competitor, they won't tell you what they're doing. They'll be closed mouth. Now, that sends up red flags, but that doesn't help you until you know where that person is, which could be months down the road. If they have an obligation to tell you where they went, usually their employer is going to say, do you have a non-compete? And if they show the employer the non-compete or the NDA that contains a provision saying, I will tell my employer, that new employer may think twice about hiring somebody who's a liability. So it's useful to have that, because you may be able to take steps before they even start working. They're going to come to you, they say, I've just been hired by your competitor, and you can go right to court before they even walk in the door and get an injunction stopping them from walking in the door, because once they do, a lot of your cats are out of the bag and the harm is done, and you want to avoid that.
So what keeps people from just putting an NDA on everything? I mean, or making it overly restrictive, $1 million damages and so forth. What keeps people from doing that, or has it hurt startups and their ability to attract talent when they do that?
So a lot of younger employees these days are much less willing to sign NDAs or non-competes of any kind, non-solicits. The courts, conversely, used to very much hate them, but these days are much more willing to enforce them. But then legislatures are now much restricting them. So you have this push-pull here that will vary from state to state, working population to working population. And you need to know who you're hiring and what you really need. You need to make sure that you don't put an NDA on everybody. I once had to deal with a client who trained horses, little kids, to ride horses for a living, and she'd been slapped with a non-compete. The court wasn't having it. At the same time, you got to make sure that the right people have them and that they are narrowly tailored to what you need. It prevents, you may only need someone not to solicit your clients. You're not so worried about the data they've got. You just need to make sure that they don't go out and take your customer base. So all you need is a non-solicit. On the other side, you may need the non-compete because there may be no way that somebody who's working for a competitor isn't going to use your information. There's just no way they could operate without doing that. That's called inevitable disclosure. Many federal courts will observe that, many state courts won't. So you want to throw that term in to make sure that they can't work anywhere they will inevitably disclose your information. But what really matters here is making sure that you tailor the non-compete to the person, the job, the risk they have. Is it customers? Is it data? Is it both? And to the jurisdiction they're in. Used to be, you could have a foreign non-compete give to everybody and it would work. It's not really that way anymore. You have to make sure that you know your audience, know your people, know your business, know your risk, and narrowly tailor it. The more accurate your tailoring, the much more likely that it's enforceable.
So are there alternatives here? Are there other ways to protect a business without using non-compete agreements, for example?
There are, but they're all generally agreements. One of the ones I mentioned earlier was making sure that nobody has access to information they don't need to do the job. So you reduce your risk in that way. Another is to have certain provisions that aren't non-competes, non-solicited at all, but they require the people to tell you where they're going, to inform their new employer that there's a non-compete. That will help stop some bad activity. You can put punishment clauses in, saying if you do this bad thing, you'll pay us a certain amount, but you have to know your state. Many states don't like those, and if they do, they limit them. So you have to make sure you know how you put it in there. Others, you can put in clauses that say, well, look, you can't compete, but if the court allows you to compete, you have to pay XYZ fee. You have to pay a referral fee for every client you take. You have to pay a certain flat amount for what you've done, things like that. Those many states will allow, again, depends on the states. You have to tailor it accurately. Putting in provisions that require people not to move out of state, and if they do, to give you as much heads up as possible so that you can have a non-compete that will work in that state and they agree to sign it. So there's a number of these things that you can do, but I'll be honest with you, the absolute number one thing you can do is hire right. If you hire people with integrity, they won't do the wrong thing. You need to have these agreements in place because no one's going to buy your company if they can't protect the intellectual property they're buying. But if you don't hire the right people, they're going to cause you problems anyway. So it's really both of these. You have to make sure you hire right, and then you have the right documents in place.
Well, so as an investor, what should I look for in a startup's non-compete and NDA policies just to know that they've got the right thing in place?
That's a good question because you need to know, one, that they all exist. You need to know who needs to have a non-compete and do they have one. And then you have to go in and make sure that it's not overbroad, that it applies to the right state, et cetera. Maybe you don't care so much about the salesperson. Maybe his non-compete doesn't work, he'll take some people. But what you really care about is the R&D people who have developed the product. Those are the people who will kill you if their non-compete doesn't work, if they don't have the right NDA. So knowing what you're buying and what's important there is your first step. Then you can narrow in on exactly what you need from whom. It takes a little time to do it right, and it takes more time now than it used to because of the complexity of the landscape. It isn't what it used to be. But knowing that is absolutely critical because almost all the time when you're buying these emerging growth companies, you're buying customer base, you're buying intellectual property, and you're buying their first mover. Those are the three major things you tend to buy. And a non-compete, a non-solicit, an NDA are important for all of these. And you have to know where it's important and then make sure you drill down and get what you need. It's also important to note that you can frequently get non-compete signed just before the deal is done. You can find out, whoa, the president's non-compete doesn't exist, and he's really critical. You can get him to sign one before the deal closes, and he'll have a lot of incentive because he's generally going to have either a founder's or other equity incentive to get this deal to close. As you go down the totem pole, you're going to find people who are more and more going to push back on that. And you may end up having to give something to them for it, a piece of the new company or the old require the old company to give them some stock, et cetera. Because remember, there's two things that you could generally tack a non-compete onto: an employment contract or ownership. And if these employees own a piece of the company and they're getting paid for it, then you can tack a non-compete in the sale documents. You don't have to worry about the employment. You also have to take an eye on who is an employee and who's a contractor. Many states won't allow contractors to be bound by non-competes. And if you have a contractor who helped develop the secret sauce, who did not ever have any stock in the company, how are you going to bind them? You either force the company to do something about it, make him an employee, et cetera, give them stock, or you lower the price because of the valuation issue that that person's going to cause.
So where's non-competes going regulatory wise? What's the direction they're taking and how does this impact startups?
They're going everywhere. And while it's exciting for me, that's not exciting for people buying startups, because it means you need to know a lot more now. Like I said, the non-compete laws aren't just non-competes. Now they deal with healthcare providers. Now they deal with small businesses. Now they deal with other very specific restrictions, and you need to know state to state. So where I see non-competes going is I think eventually there's going to be a national framework, because there's going to be such confusion at the state level that eventually I think the federal government's going to have to do something. I don't think it's going to be to outlaw them entirely, but probably to put some restrictions on them nationally. That'll make it easier. But until that time, you really need to start becoming very aware of who's signing these when they start with you. Because some states say, if you sign a non-compete when you start, fine. But if you get that non-compete after you get employment, now you have to get paid for it. And not just $1, but something reasonable. So this is one of those things that an early stage company won't pay a lot of attention to. They've got bigger things to do. They don't have a lot of money. And frequently this will be a hole, one of the things they forgot or didn't know to do. And then you find it later. So where I see this going is much more difficult, probably for another 5 to 6 years before we start seeing more of a national move. Whether that happens in 5 to 6, I can't possibly say. There's no real way to know right now. But there's definitely going to be an increased complexity on a state-to-state basis.
Well, that's great. There's quite a bit going on in space. Appreciate you updating us in the last few minutes that we have here today. What else should we cover that we haven't?
So there's a fair amount of change that's going to be happening in the employment world with regards to who is an employee versus who's a contractor. For some years now, employees have been the default. Government agencies like the IRS and workers' comp and unemployment have been saying these people are employees. I don't care if you call them contractors. That may actually reverse in the next 4 years, and we'll just have to see. Overtime is an issue that we're going to have to keep an eye on, because that may also reverse its trend. And it may become easier and easier to find people who don't have an overtime right. At the same time, the change in generations is happening more and more quickly. And I have children that are in younger generations. I see them and their peers and how they're approaching employment, how they're approaching non-competes. And it's going to be a very different world for those people and what they expect out of employers and how they need to be treated to get the most out of them. So generational awareness is absolutely something that's going to be a big deal over the next 10 years.
That's great. Well, great. So how best for listeners to get back in touch with you?
Well, you can always reach out to me at my number, 610-825-8400. I've got clients all over the country and licensed in New Jersey and Pennsylvania. And we have partners who are licensed elsewhere as well. Federal issues I handle all over the place. You can go to www.wisperl.com as well, or you can email me at cezold, C-E-Z-O-L-D, at wisperl.com.
Well, I want to thank you for joining us today. We'll include your contact details in the show notes and hope to have you back for a follow-up soon.
Oh, thank you very much. I very much appreciate it. It's been enjoyable talking to you today, and I look forward to seeing you soon.
Investor Connect helps investors interested in startup funding. In this podcast series, experienced investors share their experience and advice. You can learn more at investorconnect.org. Halty Martin is the director of Investor Connect, which is a 501c3 nonprofit dedicated to the education of investors for early-stage funding. All opinions expressed by Hall and podcast guests are solely their own opinions and do not reflect the opinion of Investor Connect. This podcast is for informational purposes only and should not be relied upon as a basis for investment decisions.